Hello, beautiful humans. Welcome to a live edition of the Midlife Revolution as we dig into the latest motions that Lori Vallow Daybell has filed in her Arizona trial, which is scheduled to start on Monday. And I, for one, was shocked to see the voluminous amount of motions that have been filed just in the last few days. And just as I was getting ready to go live with this information this morning, my internet went out. And so I would have been here earlier today, but had some technical difficulties. And I am joined today by a special guest because there's no way any one person can keep track of all of Lori's stuff. And so I invited today Joe Schmo to join me on the channel. Welcome, Joe.
Hello, beautiful humans. Hello.
And Joe Schmo has his own channel, and I actually appeared in an interview on your channel just a couple weeks ago.
And yes, you did. That was very gracious. I appreciate that very much.
Yeah, it was great. So is your channel just Joe Schmo? Is that what it is?
There's an 88 on the end of it because Joe Schmo was already taken. So Joe Schmo, and I wonder if there's an underscore between Joe Schmo and 88. I always forget.
There might be. I seem to recall. I was just going to put it in the chat here so everyone could go follow, because Joe is an excellent investigative reporter. He does such really good work. And when I realized that there were more than just a couple motions to go through today, I contacted Joe and said, can you please help me go through this, because it's so much to keep track of. And I feel like I want to do it justice, because there's a lot of detail here and I want to make sure we don't miss anything.
There is a lot to unpack. Like just with the lawyer herself, there's a lot to unpack there. And then when she's representing herself as her primary defense counsel,
right,
and she also is going to want to give her speeches from time to time and be the center of attention and all of that. I mean, there is a lot to unpack. And I think a lot of the motions show that.
Yes, there is a lot. There's a lot going on. And the difficult part of it is that, Lori has from time to time some coherent arguments. She does have advisory counsel helping her represent herself. But I feel like the issue is that she maybe gets some advice from her advisory counsel about how to proceed in a certain way. And they give her some case law to reference, but then it's sort of like, okay, this is what I want to do. And they're like, okay, do this thing. And she goes like this. And it's like, when you read the motion, it doesn't actually make a lot of sense. And she never really connects the dots. And I feel like that's what's confusing for me.
Yeah, she like, if you watch, so I've been over them twice now, except for the 4 that were dropped this morning. I've been over the recent motions twice now. I did it once on my channel on, gosh, what are we, Tuesday? So yesterday morning show, I went over them. And then I went over them again on Cresh's channel last night. And she drives me nuts because she makes grammatical errors and she makes syntax errors, but she still thinks she's the smartest person in the room, and she's not.
Lori does. Lori drives you nuts, right? Because it drives me crazy too, because sure, badly spelled, whatever. Sometimes her paralegal corrects those things, and sometimes I feel like she just leaves them exactly as they are. So we have a lot to go through today. So I want to get right to it. I just want to first say thank you to my channel members and to those of you who are Patreon subscribers. I will be doing a Patreon live either tomorrow or the next day, just depending on how the internet goes. So you can join my Patreon over there. That's where all of my bonus content is. And in addition, the Third Verse channel is sponsored by Revolutionary Media. If you are a creator who wants to monetize your skills and expertise, you can go to my website at third-verse.com and fill out the form, and someone will contact you about how to monetize a YouTube channel and benefit from your knowledge and information that you can share with everyone. So thank you to Revolutionary Media, and thanks to everyone who is here. And if you're watching us on the rewind, I really appreciate you being here. Please feel free to comment. I do read my comments if you have suggestions or information that we've missed. So without too much further ado, or ado, however
To you and you and
say
you.
it. Yeah. Let's go ahead and start going through this. Now, this is I'm trying to go through these motions in chronological order. So I just want to acknowledge there are a couple of things on the table from last Tuesday's hearing that haven't been resolved yet. The judge has not written a decision or ruled on a couple of things. That we've got some things outstanding. So I don't know about you, Joe, but I'm thinking there's going to need to be another hearing before Monday. What do you think?
I I would not be surprised at all. Or just he may just like issue orders from the bench without like
Right.
having another hearing. That's
Yeah.
probably more likely.
Yeah, it's given the volume of motions that there are now before the court, it would make a lot of sense for him to just issue some bench orders because I think having unless there's something that really needs to be argued, right? So hopefully that's what'll happen.
Yeah. And
So
it seems like she and the state have both made their arguments. She filed her motions, they filed objections to the motion, they filed their motion, she filed her objections to the motion. So they're kind of making their arguments on paper, which is probably why there are so many of them on the docket.
right, that makes sense. Well, so this first motion that we're going to look at was filed on the 18th, which was last Tuesday, the date of her last, it was supposed to be her last pretrial conference before the actual trial starts. Jury selection starts on Monday. And I find it interesting. We're back to handwritten motions now. And I think that's possibly because she sort of has exhausted the number of hours that she's allowed to use her paralegal and her investigator. What do you think about that, Joe?
Yeah, she definitely has a limited number of hours. So we're going to see in the ones that I sent you, like a few of them are handwritten and a few of them are typed out. So you're probably right that she's probably exhausting her hours that she's been granted by the state.
Yeah, so this motion was filed the same day as the hearing. So one could imagine she probably left the hearing and got right back to work on other things. So this is a motion to exclude state's witnesses, and this is the most explosive one. So we're actually leading with the most with the most explosive motion, I think, before we unpack some of the other things. This one was the one I was the most surprised by. Lori wants to, it says the defendant, Lori Daybell, requests that the state be ordered to exclude the following witnesses: Nancy Jo Hancock, Christina Atwood, and Kay Woodcock. Now, I don't know who Nancy Jo Hancock is. Do you, Joe?
I do not. I do not. I asked last night on Crushes and nobody could answer it definitively.
Yeah, I've been through all of my notes and documents and I can't find that name anywhere. That doesn't mean that it's not somebody related to the case or someone we've heard of already. It just means there's a lot, right? How many ever terabytes of information Lori has? I probably have at least half that many to go through.
Yep.
But you'll recognize the name of Christina Atwood. I believe she was one of the participants in some of these castings. Does that sound right to you, Joe?
It does. I think somebody mentioned that last night again. Yes, like that she was involved in the circle thingy that they did with the castings.
The
Yeah.
circle thingy. That's a great way to put it because castings like gives it some legitimacy, and I think it was all just BS. So, yeah, the circle thingies. This
New
is
merch. New merch. Look for Joe Smo's circle thingy merch.
circle thingy merch. Bama Cat says, does Nancy work at the insurance company they called about Charles's money? I don't know. That's a great question. I don't remember the name of the insurance agent that Lori called when she was trying to check on the on Charles's life insurance. So that could be it. And then, of course, we know who Kay Woodcock is, obviously. And so it was surprising to me that Lori's trying to have Kay excluded. So let's just read through the rest of this. Facts. The state's witnesses listed above are not for factual testimony. They only have to offer speculation and hearsay. And then she cites rules of evidence, need for personal knowledge. A witness may testify to a matter only if the evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. And I love how Lori underlines. It's like she doesn't really know how to emphasize with her words. So she'll underline the witness and then has personal twice, knowledge twice of the matter. This rule would prevent testimony to the subject of hearsay because there was no personal knowledge. again, not well written here, but we'll go with it. The alleged witnesses were not in communication and had no knowledge prior to the alleged crime. This is confusing, but we'll just plow through and then we'll go back and pick it apart. Their presence was not in location or proximity of victims or the defendant. And then she cites some more case law here. If a witness' alleged interpretation, contribution in name of another is prohibited, no person shall make a contribution in the other person. This isn't worded correctly either, or knowingly permit name to be used to effect such a contribution. And then US v. Whitmore, excludable above as legal conclusion. Testimony is unlikely to assist because, among other things, it has nothing to do with the defendant's actual case. I think that's unlikely. Rhode Island versus Innis. Impeachment testimony demonstrates untruths in statements, especially used in prior trial, thus proves guilt by implication, and therefore such statements are incriminating in any meaningful sense of the word. And then she's citing the 6th and 14th Amendment, confrontation clause, the Brady rights, again, she's going to reference rules of evidence, attacking or attaching and supporting the declarant's credibility, confrontation clause, declarant not available. What? Is she going to say that one of these people isn't available? Exception to the rule against hearsay. Testimony of a witness is excluded as not admissible. So anyway, she wraps up by saying the state's witnesses above are meant to deprive the defendant the right to due process and right to a fair trial. These witnesses will not be testifying to facts, but opinion, speculation, and hearsay, creating prejudice and bias for the defendant in front of the jury. In conclusion, the defendant requests the above listed witnesses are excluded from testifying at trial since it was discovered in their pretrial interviews that these witnesses have been communicating with each other regarding the defendant and these cases. None of these communications between these witnesses have been turned over to the defense from the state. It was discovered by the defense in these pretrial interviews that much of the information that these witnesses gave in their police interviews was gained from speaking to Kay Woodcock long before they were interviewed by police. All 3 of the above-mentioned state witnesses should be excluded from testifying at trial. Now, this is one of those things where I would think that the state would want to file a response. Do we have a response from the state on this somewhere in these documents, Joe?
Yes,
Do you know?
I believe
Okay.
we do. I believe we do. I think it was one of the 4 that was uploaded this morning, if I remember right.
Okay,
But it's
so
so hard to keep track of the whole jumbled mess.
yeah, exactly. So should we go to the response for this next instead of just because
well, if you can find it.
Okay. Well, all I wanted to say is that I think these are pretty weak arguments. It seems like what happened is that Lori interviewed these witnesses about what they were going to testify to, and she made the determination in her mind, which we all know is sometimes delusional. She made the determination that she thinks these witnesses have talked to each other, and she thinks that that they spoke to Kay prior to giving statements to police, and she's trying to exclude their testimony on those grounds. Is that kind of the conclusion you came to?
Yeah, and the problem is she doesn't really make a solid argument. I mean, she cites case law, but she doesn't really make an argument about why they should be excluded. She just says, I think they should be excluded.
Right.
So that begs itself to lend itself to having maybe a motion to eliminate filed by the state and a hearing on it, which would delay the trial by
Of course.
weeks, if not months.
Right.
And that was like the biggest conclusion that I got out of the hearing a week ago this morning. The judge said, you can either have your evidence entered from your expert that he hasn't even started extracting from any phones yet in a month or 2 months or 3 months, and we can delay the trial if you want to file for a continuance, or we can start the trial at the end of the month. And do you want to delay it? And she said no. So
Right.
that's like the biggest thing that I got out of the hearing a week ago. She
Right.
doesn't want to delay it.
No,
But
she
does
doesn't.
want to. Yeah.
And she does want to ask for her cake and eat it too, but then ultimately she decides, no, I just want my trial to go ahead. So I mean, she's going to try to shoehorn some things. So Arcturus 3, thank you so much for saying this. Just checked, and per analytics timeline, Nancy Jo is the woman Charles went on a date with the night before he was shot. So we know he was talking with this woman online, and I think they did meet up for dinner. And so maybe that's the person who is listed here. That's a good possibility. So thank you for that. Per analytics,
I would think actually that would be a good witness for the defense. Like
I would think so too.
if my estranged husband is going out to dinner with another woman, then do I not want her to come in?
Yeah, if Lori is on the
testify?
narrative that Charles was having an affair, you would think that she would want this witness to come in. But again, I think Lori is really afraid of anything she can't control. And I think she doesn't know enough about this woman and this woman's testimony, perhaps to make a good argument that way. But this is what we both have been saying, is that she cites the case law, but then she doesn't make the connection back to what she's trying to argue in this motion. So I think that I think basically what she's trying to say is that, like, look, these guys have been talking about me behind my back, and I don't want them testifying.
Yeah.
So
I don't know what they said to each other.
Right, exactly. Well, so let's just address that for a second. I don't think that it is against the rules for witnesses to talk to each other about the case until the case is started. I know that witnesses can't listen to each other's testimony, and I know that there are certain conditions under which the judge will say, don't talk to anyone publicly about the case. But as far as I know, there's really nothing preventing witnesses from talking to each other, right? Or am I wrong about that?
I don't know. I'm not a legal expert or an attorney, and I actually
Yeah.
asked for that on my live. I said, somebody come and clarify that for me. And it probably varies by state a little bit, but there's probably a good general rule of thumb. But
Yeah.
she said in her motion, I know they've been talking to each other. So that's what's on her mind, is the fact that they've been talking to each other. Yeah.
Yeah. I'm just gonna ask ChatGPT here real quick. It says, in general, witnesses in a criminal trial are not prohibited from talking to each other prior to the trial unless a specific court order or rule is in place. However, there are considerations. There can't be coordination or collusion. There's a witness sequestration rule, which can be applied before or during the trial. But as far as I know, the judge hasn't issued any rules like that.
Yeah, he actually, the only one who will be exempt from that will be Kay. She was given victim witness status in the hearing on the 11th, which means she can sit in court and listen to the other witnesses' statements, but all of the other witnesses will be sequestered and not be able to sit in and listen to other witnesses' statement until they're released from their subpoena.
Yeah. And then it says attorneys may advise their witnesses not to discuss the case with others, including other witnesses, to avoid any appearance of impropriety or accidental influence. And I get that, because, witnesses talking to each other, generally speaking, probably is not a great idea. However, Lori says they haven't provided any of the evidence related to these communications. Well, what were they texting each other? Were they calling each other? Were they speaking in person? She doesn't reference any of that.
No, and the state has no obligation to record conversations between state witnesses. I mean, that's, I mean, what are we going to go around and follow state witnesses with recorders and record all their conversations? No. And she doesn't mention specifically collusion in her filing. So
if she does have a good argument here, she would have needed to put that in her motion. She needs to say specifically, these witnesses have been texting each other and calling each other. She needs to say the state is aware of these communications. She's basically, again, asking for discovery that probably doesn't exist. I doubt very much the state has any copies of any text messages or phone call logs between witnesses.
Yeah, it's like that 2-hour interview room video from Gilbert PD. I don't think it exists. Yeah.
I don't think so either. I've looked everywhere for it, and I've asked lots and lots of people. So, okay, I'm going to try to find
I couldn't find it. I just looked through my list of the most recent filings, and I cannot find a state's response to this motion to preclude.
I think I've got it.
But maybe you can find it. I have so much. There's so much.
I know, and you've already been through this a couple of times, so I'm sure that it all kind of blurs together. So let's try this. This says response to defendant's motion to exclude state witnesses. So hopefully this is it.
Oh, you found it. Yes.
Yeah. So this is I don't know how to tell you to reference it other than by the name of the file. So it says response to defendant's motion to exclude. And it says the state of Arizona, through undersigned counsel, requests the court deny defendant's request to exclude or preclude state's witnesses, Nancy Jo Hancock, Christina Atwood, and Kay Woodcock. Defendant argues in her motion that the witnesses, quote, are not for factual testimony. They only have to offer speculation and hearsay. The defendant writes, among other things, that these three witnesses lack personal knowledge. The defendant seems to argue that therefore the witnesses are not relevant and should be excluded. State presumes defendant means precluded. Thank you for correcting that, Trina K. Disputes these allegations and provides that these objections are more properly raised at trial, not by a pretrial motion. There again, this is a pro per mistake, right? The defendant is charged with conspiracy to commit first-degree premeditated murder. The state can use both direct and circumstantial evidence to establish that the murder was premeditated. The courts have long held that although motive is not an element of homicide, it is relevant. And then she quotes State v. Hunter, the fact that the defendant had some motive, good or bad, for committing the crime is one of the circumstances which, together with other circumstances, may lead the fact finder to conclude that he did in fact commit the crime, whereas lack of any discernible motive is circumstance pointing in the direction of his innocence. So that's a clear, well thought out argument. The state submits that the motive for this murder is that Mrs. Vallow, now Daybell, wanted to kill her husband so she would obtain the proceeds from his life insurance policy, social security benefits, and be free to marry her current husband, Chad Daybell. Each of these witnesses is relevant to establish premeditation and motive. So there you go. That's a well thought out argument. I agree. Slam dunk. Hopefully the judge agrees too.
More well thought out than her filings. And I found where I had it. It was still in my downloads folder, and I hadn't moved it over to my Lori Vallow Daybell folder yet. So
Gotcha. Okay.
Yeah.
Well, buckle up, people, because that's just the first one. Okay. I don't know if you can see my list of documents here, but we've got a lot to go through. So hold on tight here for a second. And I'm going to go to the next motion that Lori filed again on the day of her last hearing. So there are 5 of them. Is that right?
On the 18th?
Yeah, she filed five documents on the 18th.
1, 2, 3, 4. 1, 2. I count at least 4. There may be a fifth one. Oh no, yeah, I see the fifth one now. Yeah.
Okay. All right. So let's get into the next one here. This one is actually typewritten, mercifully, and it is motion to dismiss for violation of confidential communication and the Sixth Amendment. So by my count, Joe, this is the third time that she has filed for dismissal under different circumstances.
Yes.
Does that track with you?
Yeah, it is, because the other ones, and I think there was one for both cases, were for speedy trial violations. That's right. And they were speedy trial violations, but under different rules. Yes.
So the first one didn't work, so she tried a second argument. Now this is the third argument.
Yes.
It says defendant Lori Daybell hereby requests that this court order dismissal of both cases and sanctions on the state. That's a pretty big deal. She's asking for sanctions against the state. Maricopa County Attorney's Office, MCAO, and the Sheriff's Office, MCSO, for violation of confidentiality and communications between attorney-client privilege. And she cites the due process, the amendments, and all of that stuff. Attorney-client privilege and work product. The state is in possession of attorney-client privilege text message communications of another state, which federal violations are upheld. That's also not worded correctly, but whatever. MCSO Estrella Facility Administration illegally obtained and provided attorney-client privilege text message communications to MCAO. Federal laws require that sanctions are imposed for remedial action of automatic dismissal of cases for judgment of acquittal, which the defendant is requesting. The defendant will show just cause to warrant sanctions and dismissal as follows. Facts. The defendant was extradited from the state of Idaho, where she will be returned to finish her sentences. The state of Arizona is only temporarily in possession of the defendant pending trial. Correct, Lori. Good job. The state of Arizona has no jurisdiction enforcing the state of Idaho laws or federal laws in another state. To whom has first what?
Mm-mm.
To whom has first obtained
that
and prosecuted the defendant. So
that tripped me up too.
again, not worded correctly. So the state has no jurisdiction enforcing laws in another state. To whom? Who? What? Where's the subject? There's no. Anyway, it just doesn't make sense. The state of Idaho upholds state and federal laws protecting attorney-client privilege as well as confidentiality in communications. This includes text messages between the defendant and her appeals attorney in Idaho, and such violation constitutes a breach of duty by both MCAO and MCSO, since neither can employ Idaho laws in Arizona. Okay, this is not the right argument, Lori, but whatever. Therefore, it's a violation of the state of Idaho and federal laws listed above. The defendant is in the appeals process in Idaho. The illegally obtained text messages between Craig Durham and the defendant are specific to work product and are federally protected in appeals court and federal court. Its contents include, but are not limited to, defense opinions, theories, and defense strategies. The agreement of both states was to preserve the defendant's due process, constitutional, and fundamental rights. MCSO Estrella Facility Administration willingly and knowingly violated the AID by providing MCAO the confidential communications between Idaho appellate attorney and the defendant, depriving the defendant's constitutional right to appeal her convictions. Again, fragment, whatever. MCSO violated.
Hold on just 1 second though.
Yeah.
Something that just struck me that didn't the first time through this document, the first 2 times through this document. Does she have proof? Does she have an exhibit? Does she have some kind of verification that the MCSO, the Maricopa County Sheriff's Office, shared confidential communications between her and her attorney?
Well, I'm fast forwarding to the end of this, and there are no exhibits attached. Oh, yeah. Exhibit A. Okay, okay. We're going to get into it. Okay, we'll get there.
Yes, all right. Let's get there.
That's what I wanted to know. Do they actually have? Okay, because look. You're in prison, you're in jail, right? They're going to review all of your communications. When they're going to review everything. They're allowed to review everything. When there are confidential communications between attorney and client, if they're specifically between the attorney and the client, they're not allowed to share those or use them for other things, right?
Right. They're probably not even actually supposed to view them. Like,
well,
if they opened up. Yeah, but if they opened up, say, a letter from her appeal attorney in Idaho that he sent to Maricopa County Sheriff's Office, and they opened it up in her presence, and they saw, okay, this is from your defense attorney, they shouldn't review it. They should just like hand it over to her and be like, okay, I know this is confidential information, right?
Right. So I'm gonna reference another completely different case. Is it the Corey Richens case, I believe, where there's the famous walk the dog letter? Corey Richens her jail cell was searched numerous times during one of the days, and they confiscated some material, written material. She had handwritten some things. One of the things that they confiscated was a letter to her brother, I think, telling him to walk the dog and then advising him on how he might testify if he was called to testify. Corey Richens claims that was marked confidential attorney-client privilege, but there is some dispute about whether that actually was marked confidential or not. So all of that just to say that the Estrella, the staff at the Estrella unit, they're allowed to see everything that she communicates, right? Because even if she's communicating with her attorney, if she's presenting a danger to herself or to others, they have a duty to report those kinds of things, right? So they can see everything. The prosecutor's office shouldn't be able to see everything, right? They should not be especially able to see anything between the attorney and the client. So let's just finish. Let's slog through this motion and get to the Exhibit A and see what we think about whether or not it's actually justified.
Real quick, that coordination between the prosecutor's office and law enforcement can get really sticky. Like I
Yep.
saw that in Delphi. I saw that firsthand in Delphi, the coordination
Yeah.
between LA and the prosecutor's office. Like they can
Mhm.
cross the line and they can file for protections like after the fact. But
Right.
okay, anyway, let's
Right.
slog
Well,
through it.
let's slog through it. Let's see what she's got as far as her evidence that she presents. Um, so just rewinding here to make sure that I didn't miss anything. Because I did scroll all the way down. So we were
You
about
did. You did. You
we
were
were
you
about
were
right
looking for
here.
exhibits.
That's right. So willingly no. Okay, this was so we read this already. Defendant's right to an appeal has been compromised because the text message contents refer to her defense strategies. So she's arguing that her appeal in Idaho is being compromised. The appeals court has no other remedial process but to dismiss the defendant's cases for violations directly related to illegally obtaining attorney-client privilege confidential communications by both the state of Arizona and the state of Idaho. Is she saying that the state of Arizona and the state of Idaho illegally obtained attorney-client? Anyway, we can come
I
back to
don't
that.
know. Yeah, I
Evidence
don't know.
obtained through intercepting messages by a government agency are inadmissible because of the mode of obtaining is unethical. The rules of evidence in criminal cases in courts in the US sitting there consequently are those of common law. The common law rule states that the admissibility of evidence is not affected by the illegality of means by which it was obtained. Every person who shall intercept, read, or in any manner intercept or delay the sending of a message shall be guilty. She's really getting in the weeds here. The state
I
nor
don't
and
even know what the common law rule is. I need to do some research on that, but I don't
yeah,
think
but
that's a rule. Is
I
there a
don't think
common law rule?
I don't think it applies here. That's the thing. She keeps citing all this case law and these different rules that I don't think they apply to this situation. Again, I think she's like throwing crap at the wall, honestly. That's what it looks like to me. Um so she's basically saying, the evidence is inadmissible because the mode of obtaining it is unethical. Well, are you saying that they obtained text messages illegally, or are you saying they're trying to use it as evidence in the case and it should be excluded? Those are two separate issues, I think. So anyway, going on, the state nor MCSO have been granted authority to obtain the communication records or text messages through judicial process, therefore violating Brady law. The federal laws prohibit both parties from obtaining a summons, subpoena, order, warrant, or consent to the attorney-client confidentiality communication privilege of another state, especially appeals attorneys. MCSO and MCAO agreed this privilege would remain intact for the temporary custody of the Idaho inmate, Ms. Daybell. The state provided the courts with intent and knowingly breached the interstate agreement contract, but breached both Idaho and Arizona fiduciary and judiciary duties with MCSO Australia administration. Again, that sentence does not make sense. It is not well worded. And I don't think she understands that fiduciary duty has to do with finances and not anyway. I could say a lot of things, but we'll move on.
I have many times.
Yeah, I have a parent meeting I have to be to in 2 hours, so I'm trying to get through um, without too much commentary. So, the violations of both MCAO and MCSO have compromised the integrity of the cases in Arizona and the appeal in the state of Idaho. The U.S. Supreme Court can and will dismiss or acquit the defendants' cases in both states. How can you say that? How are you bringing in the Supreme Court now already?
She's already ruling on she is ruling on the Supreme Court's behalf. Do you
That's
see
right.
this? Do you
That's
see
right.
that?
She's presented the case to the Supreme Court, and she has already rendered opinion in that
Yes.
Supreme Court case. Maybe she just
It's
has delusions of grandeur where this ends up before the Supreme
I
Court, and she, as pro per, gets to argue before the Supreme Court. I think that's what's in her
oh
head right now.
I
The
think maybe
Supreme
she wants to someday be a Supreme Court justice.
It's possible when she gets acquitted. I bet that Jesus will make the way for that to happen for her.
Her Jesus, yes.
Yes, her Jesus, not anybody else's Jesus. Like you might be the favorite of your Jesus. Okay. The U.S. Supreme Court can hold both judiciary court systems in violation of abuse of discretion. MCSO and MCAO continue to violate the state and federal laws by illegally obtaining, creating fruit of poisonous tree doctrine violation. That's like another completely different thing that doesn't apply here. The violation should be attached to the courts that allowed the above parties to submit the illegally obtained records, knowing the court never granted or awarded the state or MCSO to obtain such records through an order, warrant, summons, subpoena, or consent. The court is aware that the breach is to federal laws and to the laws of Idaho protecting client-attorney communication and privilege by allowing the submission to occur. Thus, violation of confidential communications with attorney work product cannot be compelled as shown above. Again, I don't think anybody's trying to introduce this as evidence, but we'll see. Compromising the defendant's appeal in Idaho. I'm not going to read the case law because it probably doesn't even apply. We'll go back and look at it if we need to. Defendant's rights include protection from improper instructions by the state. Intrusion, what? Has risk of disclosure of the confidential info. The intrusion chills free discussion between the defendant and her legal team. Well, okay. I mean,
her and herself. Yes. Like her legal team is herself.
Between her and her legal, between me, myself, attorney Lori Daybell, Lori Vallow Daybell. There's a lot of people involved here. Mm-hmm. And then, she's effectiveness of counsel due to lack of communication. Sheriff's office is eavesdropping on private consultations between a defendant and attorney. This is a wild accusation. Is she really saying that the sheriff's officers eavesdropped on her private consultation? The government,
that did actually happen in Richard Allen's case in Delphi.
I'm not saying it doesn't happen. What I'm taking issue with is that she is making several different accusations about what has gone on here. So let's
she's all over the place. She's all over the place.
Yeah. If everything that she puts in this motion is actually true and she has evidence of it, it really should be 2 or 3 different motions, or she needs to limit her legal arguments and her citing of case law to the ones that actually apply to what actually happened. So I think she's just all over. It's like you say, all over the place. Okay, so here's what she's actually arguing. The state didn't provide a subpoena to obtain the defendant's text messages. They don't need a subpoena. You're in jail, right? That's kind of what I think. MCSO rules of regulations and global tel link terms and conditions argue that the texts are not privileged. They're not. The defendant contests that her communication obtained are privileged, citing specifically text turned over to the defense by the state on February 6th between the defendant and Idaho attorney. Okay, so let's see it. In fact, they are privileged communications and non-discoverable as follows. 1, because the attorney, Craig Durham, legally represents the defendant in her appeal in Idaho. The defendant and her appeals attorney had made reasonable efforts to secure private and confidential communications to meet the expectations of judiciary process to continue in the defendant's appeal in Idaho. This is where she's going to cite, this is the exhibit she's attached. Number 2, the defendant and her legal defense believe that all attorney-client communications are privileged and protected under federal rules of evidence, blah, blah, blah. The defendant has not waived or relinquished her attorney-client privilege to Mr. Craig Durham. Exhibit A is the communication emails from MCSO to appellate attorney Craig Durham. At the time the attorney received this email confirmation from MCSO that his communications would now be privileged, defendant then presumed the same. Exhibit A also shows the extended timeline in which the appellate attorney had no access to communicate with the defendant and work on her appeal. Well, I mean, you're on trial in another state, so that's going to preclude a lot of communication, I'm guessing. Attorney-client privilege.
So is it? I think I remember from last night. Some of this that she's talking about actually did come before she was granted permission to represent herself. So some of it does actually include her prior defense counsel, if I remember right.
Okay. We'll look at the dates. So she cites a bunch more case law, work product, consent, disclosure. Okay, so let's get to the events here. We'll come back to that stuff if we need to, but I feel like we need to just get on with it.
We are seriously, we'll be here all day
We
tonight.
will be here all
tomorrow.
day. Yeah.
Yeah.
On January 31st, 2025, the Defendants Advisory Council received an email from the state containing all of the defendants' text messages from MCSO. The date ranged from October 24th of 24 to January 24th of 25. The text messages contained attorney-client privilege communications between the defendant and her appellate attorney in Idaho. On February 4th and February 13th, legal mail addressed to the defendant from MCAO was delivered to the defendant previously opened by MCSO staff, not in the presence of the defendant. Again, the legal mail was previously opened, not in the presence of it. Did you really need to restate that? And then slid under the defendant's cell door in the middle of the night. Wow. On February 15th at 10:30 a.m., so this is 2 days later, I guess, the defendant's investigator arrived at MCSO and was sent away, being told he could not meet with the defendant that day, although he had important time-sensitive documents to deliver to the defendant. This is not the proper place for this argument right here. On Monday, February 24th, at approximately 5:45, MCSO Australia Administration SRT was sent specifically to the defendant's cell for a search. The defendant's legal documents were searched by SRT outside of her presence. Well, you're not allowed to be in your cell while they're searching your cell, Lori. There is both body camera footage and pod video surveillance that will confirm that the defendant was told to leave her cell and go downstairs during the search. Due to the fact the defendant has hundreds of legal documents and thousands of pages more of discovery, it is undetermined which documents were seized in the SRT search. The defendant was asked by SRT to look into her cell and identify immediately if any legal documents were missing after they performed their search outside of the defendant's presence. This was impossible.
That's actually true. That's actually true. Like if she had thousands of documents, you could have taken one out of there and she would not be able to identify which one you took. So that's true.
That is very true. However, there's body camera footage and there's pod footage, right? So
what? Don't tell Lori that. Don't tell Lori.
I mean, if they did remove something from her cell, it would show up on the body camera footage, right?
Yep.
So anyway, moving on.
Yep.
On February 24th, legal mail was opened again and then slid under the defendant's cell door in the middle of the night instead of it being opened in her presence and delivered to her personally. On March 6th, legal mail was handed to the defendant previously opened by staff. When the defendant questioned the officer who handed the defendant the legal mail about the legal mail being opened without her being present, the officer stated that the legal mail was opened prior to him receiving and delivering it to the defendant. This is an ongoing issue. Clearly, MCSO is not following their own policies and procedures when it comes to this particular defendant inmate and how staff should be handling and delivering her legal mail. In conclusion, the state and MCSO have violated so many of this defendant's constitutional rights. The state and MCSO should receive sanctions for these egregious violations. The defense requests both cases be dismissed. Okay, well, let's see what she's got attached as Exhibit A here. So we've got an email from Craig Durham to Annalena Ramirez, which is that her paralegal?
Yes, Ramirez is her paralegal. Durham is the Idaho defense attorney for an appeal.
For her appeal, right? And so this is dated Wednesday, February 26th. I'm actually going to go down to this. These are all replies to replies. So I'm going to go down to the beginning of this email chain here. So the beginning is Melissa Rios of MCSO to the attorney about Australia jail phone information. Good morning, Captain Nolte from the Australia Jail has received your letter about the phone information. I'm reaching out on his behalf to have your phone number listed as an unrecorded legal phone number. Contact blah, blah, blah. They will assist you. Follow the instructions, blah, blah, blah. So this is the sheriff's office is telling the attorney how to get his number registered as an unrecorded. And then Melissa says, Craig Durham says, thank you very much. Is that a phone line that will be answered? I've called and often I'm on hold for a long time. Lots of O's. And she says you have to call and the message that plays needs certain information you have to leave for them. So this is the sheriff again. Good morning. Just wanted to give the heads up. An attorney sent a letter trying to get their number below listed as a legal number, instructed them to call the number, leave the information, blah, blah, blah. Then Gilbert Escobar, to whom this last email was sent, responds to MCSO saying, "Dear Attorney Durham," and the attorney, right, copies everybody. "I wanted to inform you that I've designated your main number as a legal non-recorded number. This has been verified for your contact information, blah, blah, blah. Direct bill account, blah, blah, blah," right? Okay. And then this is the last message in this chain is from the attorney to the what do you call it? Not the investigator, the paralegal, Annalena Ramirez. "Also, please tell Lori that I apparently started the inquiry to get a confidential telephone line by sending a letter, which apparently a Captain Nolte received and forwarded to Sergeant Rios. I looked, but I don't have a copy of that letter. I don't recall exactly what it said, just FYI." So she has attached as an exhibit to this very long motion to have her case dismissed communications between MCSO and her attorney, basically just telling the attorney how to get his phone number listed as a non-recorded phone number. So I'm disappointed that she attached an exhibit, which purpose would be ostensibly to give evidence of what you're alleging in your motion. And the exhibit has nothing to do with what she's alleging in her motion. If she's alleging that this is attorney-client privilege, she is incorrect. It is not. Am I wrong about that?
No, but at this point in time, based on the number of documents that I have downloaded off of her docket, it just feels like she's just throwing stuff against the wall to try and see what sticks. But she's doing. What are her motives though? That's like, because there's no way she's ever going to be free again. I mean, she told Keith in that Dateline interview that she believes her and Chad are going to be exonerated. Which, does she really believe that? I don't know. If she does, she's delusional, and if she doesn't, then what is? I guess that's my point. Only is she's just causing pain and suffering for the families of the victims is all that she's doing.
Yes. So, my sentiments exactly, Charlotte Bassett. We all know this will be a big show. I'm just.
You have okay. Hold on. 5 seconds. 5 seconds. I grew up in the Mormon church, and I have a problem with guilt as soon as I cuss. Do you have a problem with that guilt too when you say swear words?
Fuck no. This is my channel, and I say what I want when I want. And for me personally, I have to say that part of the way that I express my anger in healthy ways is by saying the actual curse words, because I felt so literally impotent every time I said fetch or shiz or frick or heck,
fudge,
or any of that stuff. And so I just really, like, I'm a big proponent of like a well-placed curse word. I try, especially when I'm online, I don't overdo it. But I also now, guess what? I don't shame my kids for cursing, because they apply the same judicious responses to things that if they need to curse, they're allowed to curse. You know, we listen to music with curse words in it, and I don't gasp and clutch my pearls. You know, I think it's a necessary part of expressing yourself authentically. It is for me anyway. And I was shamed for being authentic for such a long time that I just don't. I have zero fucks to give about anybody who has judgment for me when I curse, when it's warranted. I'm not going to like go off the deep end and throw curse words around just for fun. But this stuff makes me angry. And healthy expression of anger for me includes cursing sometimes.
Yeah, that's
so
awesome.
Thank you.
That's so powerful. Like, that really is. but Lori brings it out of us, does she not?
She does, because it's incredibly frustrating. And to answer your question, what is her motivation behind all of this? I think you nailed it. You can always count on the fact that Lori wants what Lori wants. And most of the time what she wants is recognition, power, control, attention, validation. She's trying to heal wounds, generational wounds, by putting herself on display and by trying to make herself sound smart and important. Unfortunately, anybody who knows anything about the law, she sounds stupid right now because she's not making clear, concise arguments.
She cannot even put together a complete paragraph without grammatical and syntax errors. She can't.
Right. Or leaving out subjects or dangling participles or any of that stuff. So
Yep.
Thank you everyone for being here. 543 people in the chat. I'm so grateful to everyone who showed up today. Thanks for being here, Irish Jen, even though I'm really terrible about letting you know when I'm going live. Please hit the like button. I appreciate it. It's going to help this content get out to people who need to see it. And as far as I know, Joe Schmo, Crush's channel, your channel, this is the only place I've seen this information so far. I have not seen it on Nate Eaton's channel. I've not seen it on Justin Lum's channel.
I get the scoop on him. I got Justin and Nate beat.
I agree with you. This is the only place that I've seen this information. So those of you who are here in chat, if you have other friends who follow the case and they want to know all of this information about the motions that are being filed, please share this episode with them. Go ahead and share the link with them. Yeah, I think Nate talked about it on Facebook, but he hasn't done like a full
a deep dive
on this like we're doing today.
Yeah.
So this is new information to those of you who care about the details of the case. I realize some people follow it just from a high level and they don't want to get in the minutia. So I completely understand that. But thank you guys for being here, and please share it. And please subscribe to Joe Schmo's channel. He does such a great job. Do you go live every morning with your like news recap?
No, it's about every other morning, like 3 times a week.
Yeah. Okay. Good deal. All right. Now I'm going to go back. I'm going to go back and look through the documents to see if the state filed a response to this particular motion, because this was back on the 18th that she filed this. So this is a response on the 19th to defendant's motion. That's a different thing we'll get into in a minute.
Yeah, they filed 2 responses the day after. One was about the restraints, one was about the civilian clothing.
Okay.
Yep.
Okay, here it is. This is the response.
Nice.
State's response for defendant's motion to dismiss for prosecutorial misconduct. The state of Arizona, through underside counsel, requests the court deny defendant's motion as there's been no prosecutorial misconduct. The state responds to each of the 3 allegations by noting the facts as alleged by the defendant as to each issue are simply untrue. First of all, I just want to give props to the state's office for being able to suss out that there were 3 allegations in there. Because I had to read it several times just to figure out what exactly she was trying to say. So number 1, on September 6, 2024, the state became aware that the defense had made a public records request to the Gilbert Police Department. The state emailed the defense counsel and asked them to request these items from the state. The state also requested the documents listed in the defendant's public records request from Gilbert Police Department. When the state obtained the documents that defense had requested from Gilbert, the state disclosed them on October 1st, 2024. I think she's going back to address the video that Lori had asked for, because this was in another motion, another allegation of prosecutorial misconduct by withholding discovery. So this might be about that. On September 18th, the state became aware that the defense had made a request to the crime analyst section of the Chandler Department. The state was advised that the defense request was improper because it was made to the crime analysis section rather than going through the public records request process. Another pro per rookie mistake. The state was also advised the Chandler Police Records Specialist section spoke with Laura Moyes, who sent a request for the log records for all digital devices downloaded. The state was also advised that Chandler did not know what was being requested as log records. Chandler Specialist Section advised Laura Moyes that when computer crimes detectives are involved in a case, their supplemental reports contain download information on all devices that Chandler extracts data from. All reports relating to the download of Charles Vallow's devices had previously been disclosed to the defense in that 22 terabytes of information.
Right.
Additionally,
And that point, I just wanted to make her investigator, when the judge said to him, why haven't you copied this before? You've had this for months and months. And it includes that extraction that she's requesting today. Why haven't you copied that? And the investigator said 22 terabytes. And the judge is like, yeah, because that's the world we live in now. 22 terabytes is nothing, like for real.
Yeah.
Should have had it copied. Should have had it copied and sent off to the experts already.
Yep, definitely. 100%. And the experts know, especially someone who is an expert in computer forensics, knows how to get through that 22 terabytes and find the thing that they're looking for. So the amount of data really shouldn't preclude them from just sending it. You know, if they had a problem, they would come back and say, hey, you sent me 22 terabytes. Can you narrow it down? Right. Anyway.
Right. Are we going to hear from Lonnie Dworkin in the trial, or is his stuff coming in too late?
I think the judge has been really lenient with Lori. He said if Lonnie got his findings to the state by that previous Friday before the pretrial conference last Tuesday, that the state.
And he didn't. He hadn't even started yet. He hadn't even started.
I don't know if that's true, actually, because I think what happened is that Lonnie probably did start to go through the data, but he hadn't done his own extraction. So I think he probably had reviewed at least some of the information, but then was subsequently asking, hey, can I please do my own extraction? Does that maybe make sense?
Yeah, so it does make sense.
I don't think he hadn't started at all. I just think, maybe he wanted to do his own extraction, which
she didn't get him approved for his 10 hours as of March 7th. That's what she said on March 18th. So she said at the hearing a week ago, if he spends 10 hours this week doing it. So I don't think he had done any work on it. I don't, based on that comment. I don't know. I'm speculating.
Yeah, we don't know. And the thing is, technically she was late. The judge said that. Technically, you're late. If the state agrees and we can come to an agreement about, what gets discovered and presented to the court timely, then we'll talk about whether or not to admit it. Hey, Culch, how's it going? Good to see you. And hey, Lainey, thank you so much for the super sticker. Love and respect to you as well. I hope Scotland is treating you well. And I think, honestly, his request for his own extraction is probably just a professional way of making sure that he's being as thorough as possible. Because if he's basing all of his information on someone else's extraction, mistakes are made sometimes, right? So if I were
it happened in Delphi. I'd
want to do my own extraction too. But the bottom 100%. Line is, technically she was late. And I don't know yet. We haven't seen a ruling from the judge as to whether or not Lonnie Dworkin's going to be allowed. So we don't know yet.
Yeah. By the way, I want to let everybody know that I'm getting ready to change my studio here, like in the next week. So I won't look like I'm broadcasting from my parents' basement like next time. Probably.
Joe, this is before your time, but when I started my podcast on April 8th of last year, I can't believe it's been almost a year already. I was literally broadcasting from my closet.
Yeah.
So I had a curtain up behind me so that people couldn't see what clothes were hanging up behind me. And I had about this much space between the curtain and my computer. And that's where I was until just a few months ago. So you know what? We all start where we start, and then we progress. And I think I need to have a big annual celebration.
You do. You absolutely do need to. April 8th.
Yeah. April 8th was the date of a cosmic event. I started my podcast, and also there was an eclipse that day. So anyway, there was that.
Nice.
I purposely did not start it on April 6th. And if you know, you know, that's a Mormon reference.
Mm-hmm. Yep.
Okay, let's go back and
All
finish reading what the state's response. On September 9th, the state filed the state's motion for defense to comply with Rule 15.4. On October 15th, the court issued a minute entry denying the state's request. The state is unaware of any other public records requests to either Chandler or Gilbert by the defendant or her defense team. So that's important to note, right? Lori didn't make any other requests to either police department as far as they know. Then on February 6th, the state disclosed MCSO jail calls made by defendant Lori Vallow Daybell between 10:24 and 1:24, as well as jail messages and photos from defendant Lori Vallow Daybell's tablet for the time period between 10:24 and 1:24. On March 18th, the defendant filed a motion to dismiss for violation of attorney-client privilege communications. The state is currently working on a response to this motion, so there will be another response, I'm guessing. The state hereby incorporates its response to defendant's motion to dismiss for violation of attorney-client privilege communications as part of this response. So basically, they're like putting a pin in it. We're going to have another response to that particular accusation. I guess that's what I'm getting from this. Does that make sense to you?
Yeah. Yep.
So they did disclose jail calls as well as messages and photos from her tablet. I guess it depends on what is in that.
Right.
So
are we going to have a hearing, or are we not going to have a hearing?
Yeah, I guess it depends on what they disclosed and what the reason.
Honestly, I was terrified when Judge Boreski was asking her, do you want to file for a continuance or do you want to go at the end of the month? That she was going to say, I'm going to file for a continuance, because I had literally just paid for my Airbnb for the month of April. And I'm like, no, don't continue it.
I honestly have a feeling that if Lori knew how many people's travel plans she could screw up by asking for a continuance, she would probably do it just to do it.
100%. 100%. Oh, if she's watching this, Lori, I didn't mean it. It's okay. We can go at the end of the month. We got 1 week to go.
Rando, I just happened to see this. Are you talking to me that my background needs more Lego Botanicals? Because I do have this one. But are you saying that Joe Schmo needs some? Because I think Lego Botanicals are a great backdrop. I do have lots. I have lots more Legos. They're not well, I do have I have a succulent garden, but I have lots more Legos. You can't see them, and I'm not sure I want all of my Legos. I'm not sure I want my Lego habit to be outed. I'm not ready for that yet. Oh goodness. Okay, so let's finish up here with this. I'm trying to watch a little bit of chat, but do me a favor, Irish Jen, if you see a comment or a question that I really need to see right now, go ahead and call attention to it with some emojis, and I will check it out. I have starred a few comments and questions for later when we get finished with this particular motion. So let's go back to this and see if we can slog through it here. Number 3, on March 6th, defendant filed a supplemental 15.2 notice. As to both cases, the state requested that separate notices be filed for each cause number so the state would know which defenses and witnesses applied to each case. On March 7th, the state learned that defense notice witness Nate Eaton is a reporter from Idaho. On March 12th, the defendant filed a supplemental 15.2 separately for each case, right? On March 16th, the state filed a motion to preclude all witnesses noticed on all witnesses. I didn't realize this. All witnesses noticed on defendant's supplemental 15.2 for this cause number, Charles's trial. At the final trial management conference on March 18th, the court heard from the parties on this motion. The state advised that it did not have contact information for most of the witnesses. The state also advised that one of the defense witnesses, Nate Eaton, was a reporter. Nate Eaton contacted this prosecutor after court on March 18th, and this prosecutor called Mr. Eaton back. Mr. Eaton advised this prosecutor that his knowledge about this case comes from his interviews and investigation as a reporter. Mr. Eaton also advised that he had not been served with subpoena by the defendant and he hoped to be in court for this trial. This prosecutor advised Mr. Eaton that even if he was not served, He still could not be in the courtroom if he was a noticed witness, and the rule of exclusion was in place. This prosecutor advised Mr. Eaton that this prosecutor would try to interview the witnesses and file a motion to preclude those that should be precluded at the end of next week. This prosecutor did not advise Mr. Eaton how to avoid service of the subpoena.
Is that investigator chasing him around with a subpoena? Nate, come back here, Nate.
I'm going to assume that Nate Eaton is going to comply with the law. If he is expecting a subpoena, he's going to make himself available. Although, as a side note, I can tell you that if you want to evade service for a divorce proceeding, for example, you could just stay in your house and not answer the door for 2 weeks. I have some personal knowledge of that particular circumstance, but I will not go into any more details at this time.
Yes, I won't ask if you were the server or the servee. I will not ask.
I will not tell you that I was the server in that case. Yeah, and I agree with this.
Men have to be men. They have to stand up. But why is she serving Nate? Like, is this related to Charles's case, or is this related to Brandon's case? Why is she serving Nate Eaton?
So Nate Eaton was the one who found her in Hawaii. And I think that this is absolutely right. Lori's mad at Nate for Hawaii. Lori wants to punish Nate for the helicopter report. This is all about Lori punishing Nate. It has nothing to do with justice. It has nothing to do with facts of the case. It just has to do with the fact that Lori knows if she notices Nate as a witness, he can't be in the courtroom, and she wants to punish him and make it so that he can't do his job and report on the case.
Well, maybe he can claim to be a victim too, so he can sit in the courtroom. Like, isn't everybody a victim of Lori at this point in time? And I'm saying that jokingly, with all due respect to Kay and Larry and you and the other family members. I'm not trying to make light of that, but
yeah,
I mean, she just like makes a whirlwind and she just picks everybody up in that tornado and she's like, here we go.
I have often referred to people with personality disorders as hurricanes because they absolutely do damage and destroy everybody who is in their path. And there are some unfortunate people who have to have the hurricane in their life, whether they're a co-parent or some other family member that they have to deal with. And they stay in the eye of the hurricane and they move with the hurricane and they alter their entire lives for the hurricane, because if you don't, you just get decimated. And that's a really good way to refer to it, I think, for, she's a tornado. So Jen is sending me a message. Ray Dunn says, who thinks Brandon's trial won't happen because this trial is going to be a circus? Well, I do think that it's going to happen. I don't think it'll get dismissed, but I doubt, given how things go in this case, that the judge will continue to allow her to represent herself in that case. It just depends on how things go.
Yeah, it's going to be the Judge Boreski is determined to be the judge on the second case too, because he said we're going to start jury selection on May 30th and we're going to be done by July 4th.
Yeah,
he said that on the 18th. Yeah. So if he is, I think it may get done. But if jury selection drags out to being like 2 weeks long, like Lori mentioned that her Idaho trial had 1,900 jurors sequestered for that, and we're starting with 200. Like, so if jury selection drags out to a couple weeks, Judge Boreski may not be the judge for the second one, and it may not get done in a timely fashion. And she will file a motion to dismiss on the speedy trial again. Yep.
Right. But again, if the jury selection is delayed because of her lack of experience and knowledge and all of that stuff, then there has to be an exception for that, right? So and
that's what he said. Yeah.
I reached out to Tom Evans when she made that claim of 1,900, because I was like, that seems like a lot. I think 1,900 people, potential jurors, were polled.
Oh, we're given like a survey, like a juror questionnaire. Yes. Okay. Yes. Okay.
I don't think they all were called in, because I I think it was only about a week of actual in-person interviews, if I remember that correctly. And so Tom Evans kind of was confirming that for me.
Okay, how do you say
Yeah.
voir dire? Voir
Well,
dire, voir
here
dire.
here in the US, we don't pronounce things correctly when it has a foreign origin. So they say voir dire here. Voir dire, I think is how it's spelled. I don't know. I don't know if it's French or Latin. Anyway, here's a couple more comments coming in. FYI, Nate mentioned that he has been having off the record emails and talks with Lori. Interesting. Because yeah,
What, for real?
Yeah, because I mean, anybody can talk to an inmate if they accept your request, right? So I wonder if Nate is hoping for his own Dateline moment.
Well, I looked up the Maricopa County Sheriff's Office prisoner contact requirements, and
Mhm.
you are supposed to send them a postcard with your request on a 4x6 postcard handwritten.
Okay.
I haven't done that yet, but I might. I might.
Yeah, when she was in jail in Idaho, when it was shortly after she was arrested, I was actually in Idaho as well because my daughter lived there at the time. I was actually in Rexburg, and I signed up to talk to her. I was really curious to know where her head was at and what she was going to say. Um, and she initially accepted, and then when it came time for me to like sign up for an appointment, it just kept saying no appointments available forever and ever. So I guess she probably just changed her mind, And I'm
Oh,
kind of glad,
wow.
honestly, because
Yeah.
at that time, if I had spoken to her, I probably would have been called as a witness. So I'm glad that didn't happen. And also, I don't think I would have been prepared to hear this "Jesus knows me, Jesus loves me" BS that she put down.
Yeah. Yeah. I think the interview that she did with Colby was like telling, like about how she probably handles most of those type of interviews. It's just
Right.
so heartbreaking. And to see,
Right.
to literally like, I think, did we see Colby's heart break like right there on his podcast? Like that was so bad.
It was hard and it was heartbreaking, but I think Colby already, and I'm probably putting words in his mouth and I don't mean to do that, but just to say my take on it. It sounded to me like Colby had made up his mind. If he gets a satisfactory answer, if she's lucid, if she expresses any kind of contrition or remorse, then we can see about the next step. But I think he had already decided that if she comes down with some
Yeah. Yeah.
delusional BS, then we're done. And we saw that happen real time, right? He said, "No, you can't. You cannot see my kids. You cannot see your grandkids. We're not going to be a part of your lives." I was hoping that this would go differently, but it didn't. So it seems like he was really well prepared for the expectation that it was not going to go well.
Yeah.
So,
I agree. Yeah.
all right, let's go ahead and go back to the third motion now. Again, this is another one that was filed on the 18th, handwritten. Again, thank you everyone for being here. Thank you so much for being kind to each other in the chat. I'm always grateful to see that you guys are kind and respectful to each other. It makes my job and the mod job a lot easier. I really appreciate that. And I'm grateful to have you guys here because this helps me too. So here's the next motion. Lori Daybell, this is a motion for the defendant to have removed restraints in trial. Maybe we could have said motion for defendant to have restraints removed during trial. Can we I just want to like edit everything and like reword it and make it make sense.
Yeah, like I don't have OCD about almost anything, but grammar gets me. So her
Yes.
filings like get to me.
Grammar, wording. She even allowed her paralegal to misspell her own sister's last name during the last one that we saw, the
Right?
witness
And
list.
her paralegal calls her Ms. Daybell, where
Yes.
she calls herself Mrs. Daybell.
That's right. So the defendant, Lori Daybell, requests this court, the state, and MCSO to allow the defendant to have no restraints, handcuffs, or shackles while in the courtroom during all court proceedings, jury selection, and all trial proceedings. This request is made pursuant to blah, blah, blah amendments, Brady laws, blah, blah, blah. On December 6th, the defendant was granted self-representation or pro per status. It has been extremely difficult for the defendant to manage oh, boo-hoo, Lori. I'm so sorry.
Extremely. I love how she
sorry.
puts those extra adjectives in to
Yeah.
tell how sorry her life is. Like when she said, I can't file motions because I'm in lockdown 23 hours a day. Oh, really?
Yeah.
How long have JJ and Tylee and Charles and Tammy been in lockdown?
Exactly. You're a convicted felon. I don't feel sorry for you that it's hard for you to pass papers because your hands are cuffed together.
Yeah.
Anyway. Take copious notes. Nobody said you had to take copious notes, Lori. In all pretrial hearings with handcuffs, it would be impossible to represent oneself at trial under these conditions. No, it wouldn't be impossible. It would just be difficult. And I know you're not used to doing difficult things, Lori, but get used to it, okay? Also, the defendant's appearance in restraints, handcuffs, or shackles violates her due process rights. She's probably right about that. It impedes her ability to perform writing tasks in her defense. If the defendant is going to properly be allowed to defend herself, she must not appear separate or different from the state representative. This is true. To be able to stand, walk, move about the courtroom as the other attorneys is imperative to a fair trial. If any imposed MCSO restraints cause this defendant to appear to the jury different from the state's representative, it would violate the defendant's due process rights and the right to a fair trial. This defendant's documented behavior for the last 5 years while in custody warrants no restraints, in all capital letters, necessary during trial at all, except for the fact that you're a convicted red rummer. I mean, there's that. This defendant has been through a long trial without any misbehavior at all. We know which trial to which she's referring. This defendant has only displayed stellar behavior all of the time that she has been in custody.
Stellar.
Yeah.
Stellar.
This is her histrionic personality disorder showing. In custody, incarcerated over the last 5 years. Therefore, the defendant requests that all security restraints be waived for this particular defendant. The defendant also requests the use of a pen at her trial to be able to take notes. Nope, pencil only. At the minimum, the defendant requests this court to order the state and MCSO to remove restraints, handcuffs, and shackles for all trial proceedings, both trials. Blah, blah, blah. Okay,
the Maricopa County Sheriff's Office has already agreed that she can be out of restraints for the trial and probably for jury selection, but
yeah. So this is now we're going to go to the non-party Maricopa County Sheriff Office response to the defendant's motion.
Here we go.
For the defendant to have removed restraints in trial. Okay. So this is filed by Rachel Mitchell, who's a Maricopa County attorney. And this is on behalf of the sheriff's office. So Maricopa County Sheriff Jerry Sheridan respectfully responds in opposition to the defendant's motion for defendant to have removed restraints in the trial. The following memorandum of points and authorities supports Sheriff Skinner's response. Although a defendant has the right to be free from restraints in the courtroom, concerns for courtroom safety and security may make use of restraints appropriate. Courts evaluate the need for restraints on a case-by-case basis, reflecting the particular concerns related to the defendant, included special security needs or the risk of escape. Because Arizona law does not delineate the factors a trial court may consider to evaluate particular concerns justifying restraints at trial, Sheriff Skinner provides 2 non-binding, out-of-jurisdiction cases for the court's benefit. See, these are well thought out, very well presented arguments that are relevant to the actual thing that's being argued, and I love this.
Cohesive, and we can follow along. And by the way, I got it mixed up. The sheriff said that he doesn't object to her being in civilian clothes for the trial and the jury selection, not the restraints. He does object to her being out of restraints because she might jump out of a window. Right.
I didn't see any windows in Judge Boreski's courtroom, although I don't know what the South Tower looks like. So I guess we'll find out on Monday. So this is interesting, though, and I want to note this because I think it is important to consider these things. In Minnesota v. Chambers, these are the factors. 1, the seriousness of the charge. This is a serious charge. 2, the defendant's temperament and character. Well, temperament, We've seen her get angry. We've seen her be snarky. We've seen her kind of try to keep that anger under the surface, right? 3, defendant's age and physical attributes. She's reasonably well fit. She's healthy, right? She's young enough that she could try to make an escape attempt, right? Or some kind of, heaven forbid, some kind of assault. 4, the defendant's past record. 5, the defendant's prior escapes or attempted escape. She has an attempted escape as far as we know. 6, threats made by the defendant to cause a disturbance. We don't know of any of those. 7, the size and mood of the audience. That's interesting. 8, the nature and security of the courtroom. 9, any less restrictive available alternatives. The need for restraints may be inferred from attributes of the defendant and his prior conduct. So then State v. Powell, it says nature of the charges, evidence of dangerous incidents, testimony about the restraints sought to be used, prior conduct, objection to the use of restraints, election, whether or not to testify. That's interesting. Physical facts of the individuals in the courtroom, presence or absence of victims, family, or spectators, and other factors will vary from case to case to be considered. So it says typically inmates attending trial wear leg braces and a remotely activated custody control belt, which is that shock vest we've been talking about, or shock belt, which allow detention officers to deliver an electric shock via remote control. Both devices are worn under the clothing and cannot be seen by the jury. Handcuffs, leg chains, and inmate uniforms are not typically worn during trial, and that is true for the defendant here. Okay, so they already said handcuffs, leg chains, and inmate uniforms are not worn. That's true for the defendant here. So she'll be in street clothes. She'll be without handcuffs and leg chains. In the defendant's case, MCSO has reviewed defendant's request and recognizes that defendant may need to move about the courtroom as she is appearing pro se. However, pursuant to MCSO's policies and procedures and their duty to maintain control and custody of inmates and ensure the safety and security of the courtroom, defendant cannot go unrestrained. As such, MCSO recommends, to ensure the safety and security of the courtroom, the use of a RACC vest, and in addition to the detention officers in the courtroom during defendant's trial. The RACC belt is designed to temporarily stun an attacking detainee, thus buying time for courtroom security officers to react. The belt sits comfortably on the defendant with straps adjustable to a particular defendant's body type. The belt is not visible to the jury. Further, the belt works on a one remote, one sensor system, ensuring the activation of other remotes will not trigger the vest accidentally. I'm sorry. I'm just
I think
having fantasies over here.
Yes, exactly. I was going to say we need to auction off like control of that remote control, like just for 30 seconds. If you had access to that control in that courtroom for just 30 seconds, how much would you pay for that?
I would be very tempted. Let's just put it that way. These two security devices prevent restraining the defendant in the courtroom. Without any restraints in the courtroom, MCSO would have to recommend an unarmed detention officer and an armed sheriff's deputy in the courtroom. You made reference in your live to the officer with the blue gloves.
Yes, the bailiff.
Can you
bailiff blue glove?
Can you sort of reiterate that for us here?
Yeah, that's just the guy that's in charge of bringing her out from behind court custody into the defense table. So I know she's going to be coming out within like the next 5 minutes when he walks out in his Maricopa County Sheriff's Office uniform and he has the blue nitrile gloves on. I know Lori's going to be coming out like within the next 5 minutes. So he is prisoner control. He's just controlling her coming in and out of the courtroom.
Okay, that makes sense. Definitely.
I don't know. They would have to. Okay, so the two things we saw in that filing, I think they would have to have a second person in charge of controlling that electric vest in case she got out of control. Mm-hmm. And I think it may have been in that filing that the MCSO said, if we can't put an electric shock vest on her, then we need to have an armed guard in the courtroom.
Right.
Which is unusual for Maricopa County. They usually don't have armed guards in there.
Yeah.
But they said either the shock vest or the armed guard. Pick one.
Yeah. Yeah. Okay. Yeah, I say give Kay the remote. during her testimony. Um, yeah. Okay. Okay. Good deal. So that's the response on that one. Now let's go and get to the next thing because time is a ticking away here.
Let's get through it.
Thank you,
We
Joe,
got
so
this.
much for spending all this time with me. I really appreciate your help.
Thank you for having me on.
I would not want to be going through this by myself because I already have a headache. I'm not going to go through this because this addresses civilian clothing and this has already been decided and I have a headache. I don't want to read any more of her badly spelled words. Motion to disclose all 404B. So this, I think, right, is this about the video that she claims exists but doesn't actually
I think so.
exist?
I think
Okay.
it might be.
Because this
And
is
then the state did file a response to this too.
yeah, all 404B evidence, which we don't need to go over. Okay, I feel good about that. Then this
There's,
is
if you look up the third one down is the state's response to that.
okay.
So that'd probably
Thank
be a
you.
good one
Thank
to
you
hit.
for that. So this is the response. The state has advised it intends to admit evidence that the murderer was committed for financial gain and to allow the defendant to marry another person. The state will admit this evidence to prove the murder was premeditated and to show the motive for murder was to obtain the proceeds from a life insurance policy for Charles Vallow, Social Security payments for her surviving child and herself as a mother, and allow her to marry the person with whom she was having an affair. Evidence of the premeditation and motive will be shown through witnesses and iCloud documents. The state will call a witness from Banner Life Insurance Company to show that the defendant contacted the victim's insurance company within 4 days of the murder of her husband to collect the proceeds because she believed she was the sole beneficiary. During this recorded call by the defendant, she provided a different story about how her husband died by telling the life insurance representative that her husband's death was an accident. When the defendant learned she was not the beneficiary, she advised the person she was having an affair with. So I talked to the insurance company. He changed it in March. So it was probably Ned before we got rid of him. Ned was the person supposedly possessing Charles. They can't tell me to who, of course, but it's done. I still get the $4,000 a month from SS, which is the Social Security for Joe Ryan and for Charles with relation to JJ. This statement by the party opponent about the life insurance proceeds is evidence of the premeditation. The defendant later contacted the sister of Charles Vallow to confront her about the fact that Charles Vallow changed his life insurance beneficiary. The state will present testimony from an investigator with the Social Security Administration and iCloud documents to show that the defendant was aware of how much money from Social Security she would receive for her son JJ and herself as a result of the death of Charles Vallow before she went to speak with anyone at Social Security. This testimony and evidence further support that the defendants premeditated the murder of her husband. So yeah, 404 is character evidence. It's evidence of other crimes, wrongs, or acts that is not admissible to prove character, but may be admissible for other specified purposes, such as proof of motive. And that's what they're arguing here. So thanks, Irish Jen, for that.
So this is a new filing that I just downloaded this morning. I had not reviewed this yet, and it is sobering.
Quick, but
yeah, okay.
The state will present testimony from witnesses who are friends with the defendant and iCloud documents to show that the defendant used her religious belief system as a way to justify the premeditated murder of her husband, Charles Vallow. These witnesses and documents were disclosed to the defendant on December 12th, 2023, and January 9th, 24, and February 26th, 24. So, yeah, it sounds like, Joe, that you did not know about this evidence previously.
Well, I had heard things, but I hadn't seen her filing that like lists it, or the state's filing that lists it out specifically. And it is, I mean, I knew about the life insurance policy. I knew about I didn't know about the Social Security for her and JJ being surviving heirs, her and JJ, to get the Social Security money. But just reading through that evidentiary piece by piece is so sobering. It's like, it's disturbing. This is a
Yeah.
disturbed woman. This is a very disturbed woman, people.
Yeah. Yeah, very
Mm.
much so. Yeah, so I probably a lot of people who have been following the case will have heard this call between Lori and the insurance
The
company,
insurance.
and will
Yep.
have heard they asked, how did he die? And Lori gives a long pause and then says, well, he was shot. And then there's another question, which I forget exactly what it was, but Lori says it was an accident. So, she's come up with 4 or 5 or 6 different descriptions of what happened. And she was, I'm sure what she was thinking is, I'm never going to talk to this person again. I don't need to tell them the truth. That's not important. I just want the information. So good to see you, Ruth. I will be reaching out to you. I definitely can use all the help that I can get. I made a decision yesterday. I announced my decision yesterday, I guess, to my channel members that I will, in fact, be in Phoenix from Monday through Friday next week. And the plan now is also to be there for the 2nd and 3rd week. The 4th week, I believe they're on recess. And I just have decided I'm gonna make things as easy for myself as I possibly can and not have to try to worry about parking and all of that kind of stuff. So whether that looks like renting a car or taking Ubers or bumming rides from people who live there.
We'll figure it out. We'll figure it out.
Yeah, I did have some really generous channel members who donated to my airfare for this time. So I want to say special thank you to those people who donated. And I haven't bought my ticket for the 2nd week yet. I want to do that today if I can, because I know the prices start to go up. But I just definitely made the decision. I am not driving that 13-hour drive, because that's basically,
that's murder.
It would be ridiculous for me to drive up there. Let's say I even drove up on Monday, and I would miss court that day. And then I would go Tuesday through Thursday and have to drive back home on Friday and miss court Friday in order to just spend 2 days with my kids. So I just decided flying is the right thing to do. So anyway, that's where we are with that. All right, let's get on to the next thing here. So I think the state lined out in a great way why they need to be able to admit that 404 evidence. So I think that's important. Civilian clothing, 404 evidence, order entered by the court. Okay, so this is the order from the court that personnel provide to the defendant a copy of her entire file, including information gathered by Miss Kearney, I think it's Kearney, related to her duties as part of the defendant's prior defense. So this is just the judge ordering them to turn everything over. And I'm
so Kearney is the lady that was her mediator. And Kearney is the
right?
mediator.
Oh, okay.
Mediator.
Oh, okay.
Yes. So Kearney is the gal that supplied her with the YouTube information that there was a 2-hour video out there from the Gilbert PD of that interview. So the judge was really good. Judge Bresky is awesome. He drilled her down and he's like, okay, where did that come from? And why can't that person just turn it over to the state so the state can turn over the evidence to you? And that's when Lori was like, well, my prior defense team won't supply anything to me. So that's where this order comes from, is forcing her prior defense team to supply them with all the discovery they need from that, including that video that Lori has claimed now in two straight hearings. She claimed that the state has this and won't release it. Anyway.
Right. Yeah. Thank you for reviewing that, Joe. I appreciate it. And thank you so much for gifting memberships. That's really, really kind of you. I appreciate it. And I do some members only things over here on this channel. I do more over on the Patreon, but this channel does get some members only lives, etc. Some behind the scenes things. So I appreciate that. Very kind of you.
Well, people need to be following you because you're not just Lori Vallow Daybell. You're also like human nature, right? You're like giving to all human beings. Hello,
Yes,
beautiful humans.
I talk a lot about healing on my channel, and I talk a lot about having healthier relationships and healthier religious systems, and you know, just making small changes that improve the quality of our lives. And so this is not my favorite thing to talk about, but I think it's important to talk about it. And that is why I will continue to talk about it. As long as Lori is in the spotlight, I will always be here saying, we all know a Lori, and we all need to hold people like Lori accountable for their behavior.
Right.
Thank you so much, Susan Catherine, for the super sticker. I will buy some treats for everybody to share with everybody at trial. We should have some little treats to make us feel better about the day. So yes, Aaron, Lori did leave the house that morning, go to Burger King to get breakfast for JJ, go to Walgreens to buy flip-flops, dropped JJ off at school, and then went and hung out at her sister's husband's, or her brother-in-law, chiropractic practice for quite some time. She was alone with Tylee for approximately 48 minutes, which in my opinion was enough time to sort of sway her opinion, feed her a narrative about what happened, etc. So yeah, just to recap a little bit for those of you who didn't know, that's what happened that morning. All right, now let's go to the next thing here. I think we did. Yes, we read this, right? To the motion to appear in civilian clothes, right? Or
Yep.
Maricopa
Yep.
County. Did we read this already?
It's
Well, we didn't, but it's the same thing that basically says defendant
he
filed the
said
motion.
we already agreed to let it happen for trial, so just let it happen for trial, but not
Okay,
for
got it.
pretrial. He objects
Okay.
to her appearing in civilian clothing for pretrial motions, which
Mhm.
is the SOP right now. So
Right,
it's
right.
inconsequential.
So she is going to appear in civilian clothes for jury selection also, correct?
I believe so. Yes, I do
Okay.
believe so.
That's what I got too. So I just want to make sure we're on the same page. Okay, now this is a new one as well. Notice of objection to the jury questionnaire. We're almost done here, you guys. We just have a few more things to go over, and we've almost covered everything. We've covered a lot of what's already above here, so don't worry. We're not going to be here for that much longer. But do feel free to you know, to go out and watch it back on on 2x speed. That's what I have to do a lot of the time.
This
So
is
this
a
is,
new one this morning. This is a new
yeah,
one this morning too. This was not
brand
on
new.
the docket yesterday.
Right. This was filed on the 20th. So this was after her hearing last Tuesday. This is the notice of objection to jury questionnaire. The defendant, Lori Daybell, gives this court notice of her objection to the most recent version of the jury questionnaire that circulated between Judge Boreski's division and counsel on March 20th. They were already supposed to be sending out jury questionnaires as of yesterday. So this is interesting. More specifically, defendant objects to question number 12 of the jury questionnaire and suggests that the current language be replaced with the following. The state alleges that on July 11, 2019, approximately 7:37 a.m., Charles Vallow arrived at a Chandler, Arizona residence where his wife, Lori Vallow, now Lori Daybell, and children were living. The state further alleges that Lori Vallow Daybell conspired with her brother, Alex Cox, to kill her husband, Charles Vallow. Lori Daybell denies this allegation, of course, in bold and underlined. The defendant would also like to bring it to the court's attention that the state's final trial management conference pretrial statement that was filed on March 13th was not a joint statement, and the state did not confer with Ms. Daybell or any member of her defense team prior to filing this statement. Again, she's mixing all this stuff up, and it's just confusing. The defendant requests that this court also require the state to amend the language in the final trial management conference pretrial statement that was filed on March 13th, where it states 6, brief statement of case to be read to the jury, to reflect the defendant's objection and suggested language. The state alleges blah, blah, blah. Lori Daybell denies this allegation. So she wants it in the jury questionnaire and in the pre-trial statement to the jury that she denies the allegation that the state is making.
Yeah.
I don't know. What do you think about that? Does this need to be put in there, or is it just an assumption that by pleading not guilty, she disagrees with the state?
Yeah, I have mixed feelings. Like, if that is included in there, what does it matter? Like, I think it's everybody kind of assumes it. And if it's not in there, does it matter? To her, it matters that it's not in there, or she wouldn't have filed the motion to include it. But like in practicality, if you're a juror in Maricopa County, Arizona, and you get a jury questionnaire and you see the words, the name, Lori Vallow Daybell, Lori Daybell, JJ, Tylee's names have already been both agreed by both parties to be put in there. Charles Vallow, the 11 or 12 witnesses that she's called. If you see all those names, does it matter if you say that in that questionnaire that she denies the allegations? Like, not to me as a juror. Put it in there, don't put it in there, I don't care.
Yeah, to me as a juror, it wouldn't matter. I'm going to assume that she pled not guilty, so she disagrees with the state's assertion. It doesn't matter to me. But I think Lori, she's got a bit of a complex about things like that, and she wants to make damn sure that everybody knows how she feels, So maybe that's
I kind of would too. If I were representing myself, I probably would ask for the same thing.
Yeah,
I probably
would. I think it's part of her histrionic personality, but also I can understand wanting to make double sure that gets in there.
But also, if I were convicted of 3 murders in Idaho, I would probably find a way to plead to this so I don't have to put the families through this again. Just because I have a heart that's a little different than her heart, because she doesn't have a big enough heart to do that.
No, I agree with you. She's never going to leave prison. She knows that, regardless of the outcome of these 2 cases, she's never going to leave prison. But she absolutely sees this as an opportunity to hog the spotlight again. She absolutely sees it as, a chance to put on a show, and she's going to take advantage of it because she knows this is the last time she's going to be seen in public, this case and the next case. So she's taking advantage of it. And if it were anybody with a shred of decency, they would plead guilty and not put the state and the victims through this circus.
100%.
I just wanted to answer this, Diane L. I believe that Arizona has year-round school, and so they have breaks of 30 days or so interspersed throughout the school year. So JJ was in regular, I believe he was just in regular school at this time. And yes, thank you for this. Everyone is presumed innocent. She is not special. And
she thinks she is. She would disagree with that.
Well, obviously, she is Jesus's favorite, her Jesus's favorite. And Joe Tall Chief, no, she does not care about anyone or anything other than Lori and what Lori wants. So,
has she ever, or did it change significantly when she met Chad? Like,
no, and this is the whole reason why I started speaking out publicly, is because there was this narrative early on in her first trial where people were saying things like, oh, Lori was such a great mom, and she was the primary chorister. Everyone loved her. Everyone looked up to her. And then she met Chad and boom, a flip switched and she went nuts, right? That was on purpose, by the way. I know I said it backwards.
Yeah.
I saw manipulative, controlling behaviors in her very early on, teenage years. So she was always manipulative. She was always controlling. She was always trying to get her way. And I think part of the problem with her family of origin is that most of the time she did get her way. She dictated what the family thought about pretty much everything in a lot of ways. Barry liked to pontificate and dictate religious doctrine. But when Lori told you, oh, so-and-so is a jerk, I don't like them, they treated me bad, don't talk to them anymore, the family would do it. And that's what happened anytime she discarded someone from her life. She came out with all these accusations against Joe Ryan and told the family, don't talk to him anymore, he's a P word, all of that stuff. So she's been doing this kind of thing for a long time, where she will make up allegations against someone and then engage in reputation destruction against them, discard the person, and the family goes along with that narrative.
It's amazing you say reputation destruction because of that filing. That is the motion to dismiss for prosecutorial misconduct.
Yep.
Like that's exactly what she is still doing today. Is
Exactly.
reputation destruction.
And you spot it, you got it. So with people like Lori, if she accuses you of something, most likely she's doing that thing or something very
Projection.
similar to it.
Yeah.
She projects that. So likely she has engaged in some kind of misconduct in her filings, in her motions, whatever, and she's trying to project that onto the prosecution. Paisley Dreams says, if the prosecution called you, would you testify? Of course I would. I'm going to comply with the law, but I don't have anything material to the case. You know, I have character information, I have historical information, data about the family, etc., but nothing that would be relevant, I don't think, to the case. And I'm going to push back a little on this THX 1138 saying narcissists are born. There's actually really good evidence to suggest that, yes, some personality traits they do come with you when you're born. But also there are a couple of different circumstances that can create narcissistic personality traits. And one of them is being told your whole entire life that you are special and that you are the most special. And it gives you a sense of entitlement, and it prevents you from developing empathy for other people. So I'm just going to say
that's why you should sub to Megan's channel, because she talks about that a lot. Do you not talk about that a lot?
I talk about how narcissists are made. I talk about how to identify manipulative behaviors and how to defend against them. I talk about how to deal with people like Lori when they show up in your life. And that's one of the main things I'm really, really passionate about. I believe that Adam is on the witness list for the state. He was the last person to text Charles Vallow. So of course he's going to have lots of material information to give. And yes, you can
we didn't get to that document. The state actually has their list of their witnesses.
We'll get to it here in just a second.
Do you have time?
I do. Yeah, I've got about
23 minutes.
Yeah. Northwest says you can legally fight a subpoena, but you have to show up. Yes, I have tried in the past. I was called in to testify in a case. I tried to get my subpoena quashed and I wasn't able to. So yes, I'm going to comply with the law. Was Lori treated extra special because of baby sister's death? This is an interesting question. For those of you who followed the first case, you know that one of the email addresses was Lolly Time, and Lolly is the nickname of one of the children of Janice and Barry Cox, who died in infancy. She had a congenital heart defect, and Lori was born just about a year later, I believe. And I've often wondered about Lori's name. You know, I've often wondered about Janice having a baby died whose name was Lolly, and then naming Lori, something so close. You know, I've always wondered about the psychology behind that. I do have a members only video on my channel about Lolly's death and the circumstances surrounding that. It's a bit of a sensitive topic, so that's why it's not just public. So yeah, Lori was born after Lolly, but I do wonder if she got special treatment because, you know, they were worried that, you know, Lori might pass away after having experienced the death of Lolly. So think about that, you know, for those of you who are able to have any compassion at all for Lori's mother, who's Janice. And yes, she is on the witness list. She's on Lori's witness list. Janice had 6 children, and only 2 of them are still alive. Stacy died when she was 32. She was the oldest. Alex died in December of 2019. Then there's Adam, who's still alive. And then Lolly died. And then Lori was born, and she's still alive, but I don't count her because she's serving life in prison. So I don't count her as one of Janice's living children. And then Summer just after that. So is that 6? That's 6, right? Stacy, Alex, Adam, Lolly, Lori, Summer. That's 6 kids. Only Summer and Adam are alive and out of prison. So if you have any compassion at all for for Lori's mom, Janice. That's where my compassion for her comes from, because that's a lot to deal with.
That's deep. That's kind of like Lori has 2.5 husbands alive, or ex-husbands alive right now, right? Because Joe is gone, Charles is gone, and Chad is on death row. So she only has 2.5 ex-husbands or current husbands alive right now.
Yeah.
She leaves a trail of bodies behind her.
Yep. She does. And literal and figurative. You know, I've talked about this before, but one of the interviews I did, the interviewer said to me, "How do you feel about the idea that murderers kill their families too?" And I believe it's true. You know, there are 50 or more family members who have been affected by these tragedies and these crimes. The ripple effect is going to continue to go out there, and it's tragic and horrible. And I have a lot of compassion for everyone who's been touched by this case in any way. So it's a lot to deal with, and I appreciate you being here, Joe, and I appreciate all of you who are watching or who will watch, because this does help me. It helps me process my feelings about this really horrible tragedy that I've had to live with, that, you know, back when, after between the time the children were found and the time that Lori's case started, I was completely alone dealing with this by myself. And I didn't have an outlet like this. And so the contrast is so stark to me. It's very different. It's very much healthier for me to be able to talk about this and to process it with all of you who are processing it too. So I'm grateful for that.
And it's so, watching you and interacting with you is a lot to me like watching Colby, because he is real and he is raw and he is honest where he is right now. I don't know where he was a year ago. I didn't know him a year ago or 2 years ago. I don't know where you were a year ago or 2 years ago. That you are real and you are raw and you are honest, and we're all trying to process through stuff together, right?
Yeah.
So thank you for that. Thank you for that.
Yeah, thank you. So I don't know if we've gone over this. I know we haven't read this specifically. But I wanted to look at this motion by Lori. I know we've sort of addressed this already, but this is new, right? This filing
Yes,
is new.
Yes.
Okay.
Uploaded to the internet overnight.
Okay. So this is a motion to dismiss for prosecutorial misconduct. And Lori did address some of these things in her prior motion, but she's listing some additional things here. So I want to go over them. On or about September 6th, Trina Kay directed, and she's the prosecutor, the lead prosecutor, directed Chandler and Gilbert to refuse to provide public documents to the defense, interfering with the defendant's right to conduct an investigation. I'm dubious about that. On or about January 30th, Trina Kay obtained and distributed attorney-client privilege communications between the defendant and her appellate attorney. Again, if what we've seen is what she's referencing, there's nothing confidential in there. On or about March 11th, Trina Kay gave legal advice to defense witness Nate Eaton in an off-the-record conversation regarding how to avoid being served with a subpoena. So the state's already just responded to this, right? This is what we read was their response, that they didn't do this, is what the state said. Ms. Kay has personally thrown her ethics and duties out the window. That's called defenestration, Lori, if you want to use a better word, in order to win this high-profile case in front of a worldwide audience.
Wow, her grandizement of everything is just so disturbing to me.
Yeah.
Like, she uses phrase like thrown them out the window in a legal filing. That's not appropriate language for a legal filing.
No.
And then in front of a worldwide audience. So she's very well aware of her audience, and she's playing to her audience right now. Is she not?
Exactly. Elaine McKenzie, thank you for the super sticker. And I'm so sorry that you're dealing with your mom's illness. I just have a lot of compassion for you and big hugs to you from far across the pond. Thank you for this. I have a sister who's much like Lori, just not homicidal. Your honesty helps me figure out how to deal. And that's what I'm here for, helping people figure out how to deal.
And I hope your sister doesn't ever become homicidal.
Yes, I hope not too. You know, it's about calling them out for their harmful behavior in the safest way possible, right? So going on with Lori's assertions here. Anyway, I'm just going to use the word defenestrate as often as I can because I just love that word. But that means to throw something out the window. That's what I would have chosen, but Lori didn't choose that here. Because this court has ignored the state's conduct, Trina K became more blatant in her disregard for her ethical obligation. This is sadly similar to her longtime boyfriend Juan Martinez's behavior in a high-profile case years ago here in Maricopa County. It seems her behavior is not original. These are some wild accusations from Lori, bringing in the boyfriend of the prosecutor.
And this is hot off the press. This is just uploaded overnight, literally. Wow. Like this may be the first place you see this. This is crazy accusations.
This is crazy. Okay.
But I'm not going to lie. I've heard it before. I have heard it before. Sure.
Any of you super sleuthers out there who want to Google this real quick, okay, please Google Juan Martinez attorney, high profile Maricopa County case. I want to know about this case. This court is obligated to discipline officers of the court for misconduct. This misconduct is egregious and needs to be addressed by the court. The actions that the defendant is seeking this court take as a result of Ms. Trina K's misconduct are the following. 1, removal from above cases for prosecutorial misconduct. 2, sanctions by the court of dismissal charges. 3, disbarment by the state of Arizona. She is asking for the prosecutor in this case to be disbarred.
Wow.
I'm just blown away. I thought this was all going to be a lot more just dry silliness. And this is out.
Oh my
okay,
gosh.
Is it the Jodi Arias case?
I don't know. I heard that the prosecutor in this case was the live-in boyfriend with him for several years. I don't know if they still are. I'm just telling you what I heard. This is just rumor, just gossip. So she found this out and she put it in motion. Oh my goodness.
I mean, this has to be coming from one of her advisory council. Like, there's no way she would just know this stuff, right?
Right. Eliza says, yes, it was Arias. Yeah.
Okay. Juan Martinez did not represent Jodi Arias. He was the prosecutor who led the case against Jodi Arias in her. Okay. So he was the prosecutor. He successfully convicted Jodi Arias of first-degree murder for the 2008 killing of her ex-boyfriend, Travis Alexander. He worked for the state, arguing against Arias, while she was represented by her own defense attorneys, including Kirk Nurmi and Jennifer Wilmot. Martinez gained national attention for his aggressive prosecution style during the highly publicized trial. I'm going to any allegation of... I can't talk and type at the same time. Prosecutorial misconduct on the part of Martinez. Thank goodness for ChatGPT.
A little bit better than Dr. Google.
There were multiple allegations of prosecutorial misconduct leveled against Juan Martinez during the Jodi Arias trial. These claims were raised, but maybe she talked to Jodi in jail. What do we think about that? They're in the same, aren't they in the same place?
Well, Maricopa County is not the same as Arizona State Pen. So you're in
true. And she's in Estrella, not in the actual prison. So that's true. Thank you.
Yeah.
Okay. Eliza Osborne says Martinez leaked information to a blogger with whom he was having a sexual relationship and then lied to investigators about their relationship.
Gosh.
Goodness gracious.
Oh my gosh, dude. But he is not associated. He's not associated with this case, except that he lived together with the prosecutor for a while.
Right, but it's not a case of guilty by association. It's really not. You can't argue that.
She
Paisley
can.
Green
She's gonna.
says, well,
She did.
she's gonna because she thinks she can. He got the ME or a detective to change their testimony allegedly, and allegedly one misrepresented a few things. Okay. Jody was LDS as well, another Mormon murder. And yes, I've seen the ties. I've done the research. It's not something I have brain space for right now. Church of Korihor, we just dropped a huge bombshell in the middle of this live stream. I hope that you are here for it. This is just crazy stuff.
Wow.
Goodness.
I hadn't
Okay.
looked at this document before we went live either, so I'm
Thank
shocked.
you. Yeah, me too. Thank you, Eleanor, for clarifying. Travis was Mormon. Jody converted.
Just like Lori was Mormon and Charles converted.
Charles converted. Yep. Okay. Why is she even bringing this up from years ago? Well, because she can, because she has a personality disorder, because she knows she's guilty. She has no case to stand on. So she keeps trying to get it dismissed because she knows that the evidence that comes out is going to be really damning. So apparently there was a big question if pew pew or fork came first, and it kind of mattered. Although at this point, I don't know why I'm editing myself because we've said the words so many times.
Are you talking about Charles Vallow?
No.
Was he shot?
No, this was in the Jodi Arias case. There was a big question which came first, and it mattered. Yes, and thank you for clarifying. Jodi is in prison. Lori's in jail. It's different. That's okay, Church of Korihor. We will go over it again because this is crazy. Go back 5 minutes and watch it on 2x if you really want to. Yeah, so I'm just reading here. Here are the different allegations of prosecutorial misconduct in that case. Aggressive conduct and witness intimidation. Martinez was accused of using belligerent and harassing tactics during the trial, including aggressive cross-examination of defense witnesses. The Court of Appeals upheld Arias's conviction, noting a pattern of intentional misconduct that saturated the trial. Examples included intimidating witnesses with argumentative questions and innuendo to the point where one witness asked, "Are you angry at me?" during cross-examination. Okay, media and self-promotion. Defense alleged that Martinez engaged in improper self-promotion by courting the media, such as signing autographs and taking photos with fans outside the courtroom. The Court of Appeals criticized this behavior, stating it was beneath the office he held. I would tend to agree with that, and violated a prosecutor's duty to uphold trial integrity. So it didn't directly affect the jury's verdict. Martinez was also accused of attempting to manipulate the jury process. Specifically, he allegedly leaked the identity of a holdout juror to a blogger with whom he had a personal relationship, aiming to disqualify her after she resisted voting for the death penalty. He was accused of communicating.
That's no bueno. That is not good.
Yeah,
jury tampering? No.
That's real bad.
No.
He was also accused of communicating with a dismissed juror to gain insight into the jury's leanings, including receiving explicit photos from her and then lying about these interactions to investigators. So if you're just joining us, Lori filed a motion that is fresh. This is brand new this morning, just uploaded this morning, to have motion to dismiss the case for prosecutorial misconduct. She's alleging that Trina K has thrown her ethics and duties out the window. And then she says, this is sadly similar to her longtime boyfriend Juan Martinez's behavior in a high-profile case years ago here in Maricopa County. It seems her behavior is not original, and they're asking for her to be removed from the case, to receive sanctions, and to be disbarred by the state of Arizona due to her prosecutorial misconduct. So we were just digging in a little bit because apparently she lives with Juan Martinez, who was the prosecutor.
Or she has in the past. I don't know if that's current.
It just says longtime boyfriend. That could be any sort of a situationship. But Lori is basically trying to say guilty by association over here. This is craziness. Lori has no right to call that in to question. She has no right to bring the other prosecutor in. Honestly, it could be, Jen just sent me a comment that this has to be Barry Cox digging for this crap. I honestly don't know how involved Barry is. But it sounds like him, right? I unfortunately downloaded his book. I'm reading it, so you don't have to. I will go over it with everybody. But Barry loves to embellish. He loves to exaggerate. He loves to make more of a thing than there is. So this kind of does have Barry's fingerprints on it. I'm not going to lie. But I don't know.
Let's invite him on for a live. Come on, Barry. Come on.
No,
Come on
thank
up for
you.
a live.
There are
on Joe Schmo. Barry, you can come up on Joe Schmo's channel.
You are welcome to, Joe Schmo. I wish you all the best of luck. He would make a fascinating interview if he is in fact coherent. But I have about 100,000 things that I want to say to him that have nothing to do with this case, and I will not engage that man.
Yeah, I bet you do. I bet you do.
Absolutely necessary. So this is crazy. Yeah. So his book is called How the Public Can Dismantle the IRS. It is basically an expansion of the brief that he wrote when he sued the federal government, saying that the IRS...
Didn't he get in trouble for not paying his taxes?
He did go to jail for tax evasion.
And he wrote a book. So let's all follow his book. Let's read his book and follow his book so we can all end up in jail too.
Yes. You too can spend some time at Club Fed if you follow Barry's advice. All right. So this is the wildest thing that I've seen. I probably will do a shorter video just on this one motion because I think it's so important. And then this is the response to that. And I think we already read it. Did we not?
I think we did. Yeah.
So props to, because it's 323. So she filed her motion on 321. This response was filed on 323. Props to Trina K for not destroying Lori for doing the guilt by association thing. She doesn't even mention it in here at all, which I think is the professional way to do it. So
can you imagine how exhausted she is? Can you imagine how exhausted Trina is?
Can't even.
No.
Can't even imagine it. We've already been over this, right? Response to all
404B. Yep.
And to exclude state's witnesses, we've been over that because that was filed this morning as well. And then this is the final thing. We're almost done, you guys. This is the last document. Look at that. Only 2 hours and 7 minutes in. Only 686 people in the chat. Please hit a like. Thank you guys for being here. I really appreciate that. Crystal Trickle, Barry's sentence was 1 year and 1 day. I believe he served all of that time. Maybe Barry has some parenting advice for all of us. Okay, now I'm getting snarky and I need to stop. I'm tired. I've got a headache. Okay, so this is the state's amended final trial management conference statement. And this is the one that Lori said, hey, they didn't consult me, right? Is this what she's complaining about?
Yes, she wasn't there for the final one. Yeah.
Right. Through undersigned counsel, hereby submit the state's final trial management conference statement for the above entitled action. List charges and sentencing range. Count 1, conspiracy to commit first-degree murder. C1F dangerous. On 7/11/2019. Life without the possibility of release on any basis until the service of 25 years. Settlement status, plea offer, no offer. They did not offer her a plea. So that could be why she didn't plead guilty. Settlement conference did not occur. Are the defendant and the state willing to further discuss settlement? No. Number of trial jurors and alternates, 12 jurors plus 4 alternates. And here are the state's witnesses. This is what I've been wanting to know. Chandler Police Department, Detective Coons, Nathan Duncan, Marissa Francisco, Jason Hunsaker, Robert Krautheim, I think, William McDonald, Nathan Moffett, Ariel Werther, Erwin Wiersbicki. Is that right? Cassandra Inclan. I'm sorry if I messed any of those names up. Chandler Fire Department, Kent Keller, Scott Cowden. If you've seen any of the FOIA documents, these are the people who were on scene that morning. Department of Public Safety, Jeff Moberg. OME, Dr. Derek Baumgardner. Office of the Inspector General, Mark Seri. Banner Life Insurance, Robin Smith Scott, Custodian of Records. Civilians, Christina Atwood, Adam
Hold
Cox.
on. Was Robin the gal that took that phone call from Lori, do you think?
So I think Nancy Jo Hancock took the call, but Robin Smith Scott is the custodian of records. So she would be able to testify to when the change of beneficiary was made, etc.
Okay, gotcha.
So she would have been able to see the actual document, the actual, policy, etc. So she probably would have.
Right. But that phone call is huge. Like seriously, Lori calling in and saying, "Hey, when can I get my $1 million?" And then being like, "Never."
Right. Elizabeth Jones, I'm sad if this is the last thing you listen to before you go to sleep. You need to do some brain cleansing, so that you're not dreaming about this at night. Okay, then civilians, Christina Atwood, which I believe was one of the, what did you call it? Circle stuff? Circle nonsense? Not the castings is what I was calling it. The casting participants. You said something about the circle craziness. Adam Cox, Nancy Jo Hancock, Serena Sharp definitely was one of the casting participants, and then Kay Woodcock. Estimated trial days, 5 weeks. Jesus, take the wheel. Brief statement of case to be read by jury. The state alleges that on July 11th, 2019, at approximately 7:37 a.m., Charles Vallow arrived at 5531 South Four Peaks Place, Chandler, Arizona, to pick up his son from the residence where his wife, Lori Vallow, now Lori Daybell, was living. The state further alleges that Lori Vallow Daybell conspired with her brother Alex Cox to kill her husband, Charles Vallow, so she could marry Chad Daybell and obtain money from Charles Vallow's life insurance policy and from Social Security. Special jury voir dire questions to be filed separately. List of standard jury instructions plus original and one copy of any special jury instructions to be filed separately. So we made it, everyone. We made it through everything that has been filed so far. This was a lot. Joe, I'm so grateful to you for spending all this time with me going through this. I could not have done this on my own. I would have given up halfway through.
Well, thank you for having me. I appreciate it very much. It was an honor.
Yeah.
It was.
I just want to answer a couple of questions or just comments here. I think Kay intimidates Lori. I think anybody who calls Lori out on her BS is someone who Lori doesn't want to talk to, who Lori is intimidated by. Lola Z says, I'm a regular subscriber. I've been following you for a while. I'm really hoping to follow you during the trial. Will that content be available to non-Patreon people? Yes, absolutely, 100%. The majority of the content that I put out on the channel about the case is going to be available to non-subscribers and non-Patreon members. What I put on my Patreon is more personal stuff and things that I don't want out there on the World Wide Web for everyone to see, but a little bit of behind the scenes things, you know, my dogs, my music stuff, my cooking, things like that. Members only lives on this channel tend to be things where if I know I'm going to have lots of feelings about something, I'll do members only just so that I'm not, you know, crying in too big of a public forum. So there's that. It's not funny because Justice for Charles is serious, but I can't help but laugh at Lori's inability to write clearly and Megan's reactions to how mixed up this mess is. So true. Yeah, so just a big thank you again to Irish Jen for moderating today. Thank you for everyone for being kind in the chat and supporting each other and answering each other's questions. Thank you for liking. If you subscribe to the channel, you'll be sure to know I tend to go live impromptu because I'm bad at planning ahead. That's my ADHD. I just really appreciate you. Thank you to my channel members and to everyone who gifted memberships and gave super stickers and super chats today. I really appreciate your support, and I will be here throughout the entire thing. I'm going to do a case recap here towards the end of the week. I'm going to do an episode about Barry towards the end of the week. And then starting on Monday, I'll be live from the courthouse during breaks and afterwards for a recap. I'll probably have Joe Schmo and other guests who were there live together. So I just look forward to talking with you guys. I look forward to helping unpack all of this for you as a family member who spent a lot of time with the Coxes. I just know how the family operates, and I think it sheds some light on some of the behaviors and problematic things. Again, Joe's channel is Joe Schmo 88. Did we ever find out if there's an underscore?
There's no underscore. It's just Joe Schmo 88.
Yes, please go
Straight
to Joe's
up.
channel. Please subscribe to his channel. Please go like all of his videos and comment on them. And let's get you up to 1,000. You're almost there.
I am almost there.
Where do you know where it's at right now?
Somewhere just under 900, I think, the last I looked.
Okay, I think it was up above 900 when I looked this morning. So
what?
And we've got 666 people in the chat, y'all.
Oh dang, I'm at 923.
Yay!
Only
okay, everybody
77 more to go.
If only 20% of you go and like his channel, we'll get him closer. Go 40% of you and go like it. So that get him up over 1,000. Joe Schmo deserves monetization. 100%. Let's go do it. Make it happen, guys. Make it happen, beautiful humans. All right. I will be tonight on Tuesdays with Tim on Latter Daily Digest this evening, and more shenanigans to come. Thanks for being here. Please take care of each other. But most of all, take care of yourself. Go do some self-care, especially you, Joe. You deserve it for all of the hard work you've done on this. Thanks so much. Take care, guys. Hello, beautiful human. Thank you so much for watching today. Would you do me one quick favor and take a second to subscribe to the channel? It's the best way that you can support the channel for free. In addition, if you're interested in even more exclusive content, you can join the community at the link below. Thanks so much for being here.